Counsel,
Go ahead.
you don't dispute that there could be judicial review by the state court of a federal constitutional violation.
Correct, Your Honor.
You don't dispute that federal courts and state courts can both review a provision for violation to the federal Constitution.
Correct, Your Honor.
But you are disputing that the state courts can't review a state legislative voting system to find whether it complies with the state Constitution?
Well, it can for procedural reasons, like in Smiley, like there wasn't presentment to the governor.
So let's go to the substantive procedural reason still distinction makes no sense to me, because the only thing the Constitution, as I mentioned earlier, controls is the procedural issues, time, place, and manner. But take a line item veto provision, for example. In more than 40 states, these provisions empower governors to accept or reject legislation by altering its content. If, for example, a governor partially vetoes a bill to appropriate funds to administer congressional elections, is that a substantive constraint or a procedural constraint? Just a yes or no.
It's procedural.
Oh.
It's a hoop that has to be jumped through.
Okay. So the governor vetoes a map drawn by the legislature and decides it's constitutionally permitted. Why is it substantive?
We're not saying. We're saying if a governor, consistent with Smiley, if a governor vetoes...
No, the constitutional provision permits him to alter the content.
Oh, to alter the content.
That's what I said.
That's the key distinction. If it's a hoop that has to be jumped through in order for the legislature to get the code of elections it wants, it's procedural. If it's a limit on their substantive ability to get the code they want...
Is it yes or no? Can the governor do this?
Can the governor change the substance? No.
Yes. No. So that becomes substance instead of procedural. So your first answer has now changed.
A veto is
what about a
permissible,
state
changing the
constitutional
substance is not.
provision that precludes legislators from acting during special sessions on certain matters? Could a state court reject the congressional election bill if it is outside the scope of a special session? Yes or no?
If it's outside the scope of a special session, that is a substantive limitation because they can't start the process.
It seems to me it's procedural in its most common understanding because it's a question of how you do things, not what's in it.
If you can't start the process, then it's a substantive limitation.
It seems that every answer you give is to get you what you want, but it makes little sense. We have more than one occasion said that we describe the task in Mistrata of distinguishing between substantive and procedural rules as a logical morass that the court is loath to enter. And I simply, what I don't understand is the question that Justice Jackson asked you, which is if judicial review is in the nature of ensuring that someone's acting within their constitutional limits, I don't see anything in the words of the Constitution that take that power away from the states.
It comes from the fact that it's a federal function, and with respect to the legal morass, that's when this court has taken a functionalist approach. We're adopting a formalistic approach, and it's my friends on the other side who are adopting a functionalist test. You can see this on page 57 of the state respondent's brief.